Good morning. Sorry for the delay in getting started. I'm going to call the next case, cause number C190050CPS. This is in the interest of Ayla Branch and Elisa Branch, children. The case is set for a bench trial today. The trial is being conducted pursuant to emergency orders of the Texas Supreme Court via Zoom video conference. Participating in the trial today on behalf of the department is caseworker Trey Davis and regional attorney Samantha Jordan. The mother of the child is Skylar Anderson, and I don't believe Miss Anderson is currently present. The mother's attorney is J.W. Johnson, who is joining our conference as we speak. The father of the child, the children, is Adrian Branch, and I believe Mr. Branch is participating in our hearing today. Emmett Fleming is the attorney ad litem for the children, and Mr. Fleming is participating in the hearing today. The Casa Garden ad litem representative for the children is Cassie Roberts, and Ms. Roberts is participating in the hearing. And I need to correct the record. I believe I indicated Ms. Anderson is not present, but I believe, in fact, she is present with Mr. Johnson in his office.
Yes, she's present.
Okay, good. Thank you. And the children are excused from participating in the hearing today. As I noted earlier, this case is set for a bench trial today. Ms. Jordan, is the department ready to proceed with the trial today?
Yes, Your Honor, we are ready, and I believe we have an agreement in this case.
All right. Is there any objection to Ms. Jordan setting forth what she understands her agreement is, and then I can verify with the other parties if that is in fact their agreement?
No objection, Judge.
Okay. Mr. Fleming, any objection? No. All right, go ahead, Ms. Jordan.
Thank you, Your Honor. We would be asking for sole managing conservatorship to the paternal grandmother, Miss Nikki Branch. We're asking each parent be named a possessory conservator of the girls. For mom, her visitation would be a step-up plan. Step 1, supervised visitation for a period of 4 weeks per week as agreed upon. If there's no agreement, visitation would be on every Saturday of the month from 12 noon to 4 p.m. And this would continue for a period of 3 months. Then my next sentence goes towards all 4 steps in the step-up plan. Ms. Anderson, on a monthly basis, will provide to Ms. Branch the results of a drug and alcohol test, reflecting that she tested negative for all illegal drugs and alcohol. If she tests positive in any step, we would ask that she revert back to the beginning of that step. So step 2, visitation would be for a period of 8 hours per week as agreed upon. If no agreement, visitation would be each Saturday from 10 a.m. to 6 p.m. And this would continue for a period of 3 months. Step number 3, visitation would be unsupervised on the 1st, 3rd, and 5th Friday of each month at 6 p.m. to 6 p.m. on Saturday. So 24-hour overnight visit. And this would continue for 3 months. Step 4, visitation will be unsupervised on the 1st, 3rd, and 5th weekend of the month from Friday at 6 p.m. to Sunday at 6 p.m. And this would continue for a period of 6 months. And then step 5 would be the standard possession order. For Mr. Branch, his visitation would be supervised as agreed upon between him and his mom. And if there's no agreement, visitation on the 1st and 3rd Monday of each month from 6 p.m. to 8 p.m. Each parent would pay child support according to the minimum wage guidelines, plus $25 per month per child in cash medical support, and then 50% uncovered medical bills and deductibles. And the grandmother, Miss Branch, would secure health insurance for the girls.
Let me just go back through that real quick because you were going through it pretty quick. But as on the mother's visitation, the first phase, and I thought you said something about for 4 weeks, but then you later said 3 months. So I'm not clear about that. But as I understand it, the first phase is it's as agreed, but if no agreement, it's on Saturdays from 12 to 4.
Yes, Your Honor. I meant 4 hours per
4
week.
hours. Okay.
Yes, sir.
All right. And then the second phase after the first 3-month period would be 8 hours per every Saturday, 10 to 6 p.m., 10 a.m., 6 p.m., and that would go for 3 months. Then the third phase would be unsupervised, first, third, and fifth from Friday 6 p.m. to Saturday 6 p.m. for 3 months. And then the fourth phase is unsupervised, uh, first, third, and fifth first, third, and fifth weekends of each month from Friday at 6 to Sunday at 6. And then that would be for 6 months. Is that right?
Yes, yes, sir.
Then the standard possession order would go into place for Mr. Branch. It would be as agreed, but if no agreement, then it would be the first and thirds Mondays from 6 to 8, and that's unsupervised, right?
It is supervised
Supervised.
if there's,
Okay.
yes.
Okay. And then the child support, minimum wage and $25 per child cash medical, and 50/50 on the health insurance and dental, with I'm assuming Ms. Branch being responsible for obtaining health care or health insurance, right?
Yeah, that's correct, Your Honor.
Okay, thank you. Mr. Johnson, I ran through that pretty quick. Was that your understanding of the agreement?
Yes, it is, and my client's in agreement with that.
Okay, thank you. Mr. Branch, is that your understanding of the agreement?
Yeah, I understand, but I don't understand. Why do I have to have supervised visit?
Well, you don't have to have anything if you don't agree to it. My understanding was this was y'all's
No, I'm
agreement.
talking about
If you're not in agreement, that's fine. You're not required to agree, and we'll have a trial, and the court will determine whether or not to order visitation or what that visitation might be. Now, if y'all are in agreement, then the court will approve that agreement. But the reasons for why they're wanting that or not, I'm not going to get into. That was something I assumed y'all discussed. If you're not in agreement, that's fine, but we'll need to have a trial.
I'm in agreement. I'm in agreement to it. I just didn't know what the stipulations were, but I understand.
Okay. Well, I mean, I'm not trying to get you to agree or disagree. I just, if you're not in agreement, that's fine. But I'm not in a position to try to explain to you why the department may or may not want those requirements. That's part of their position in the case. But I just want to confirm for the record, you're in agreement with the court entering these orders. Is that right? Okay. I'm going to need a definite yes or no, just so I'll have a
Yeah.
record on it. Yes, you are.
Yeah, I think so.
Yes.
Okay. Thank you. All right, Mr. Fleming, what is your position on this? Are you in agreement with these orders?
Absolutely, Your Honor. My clients, the girls, are 7 and 9. They're absolutely happy and overjoyed to be where they are. So I concur.
All right, thank you. And Ms. Roberts, your position or agreement on are you in agreement with the proposed orders?
Yes, CASA's in agreement.
All right, thank you. Well, then the court, based on the announcements of the parties, will approve the agreement, enter in judgment consistent with that. The court will find there's been a material and substantial change in circumstances of the children and the parents since the prior orders were entered relating to the children in the case that was consolidated with this case, and that it would be in the best interest of the children for Nikki Branch to be appointed as the sole managing conservator of the children with all the rights and duties of a non-parent sole managing conservator under Texas law, including the exclusive right to designate the primary residence of the children without geographic restriction. The parents are each appointed as possessory conservators with their visitation to be as outlined by Ms. Jordan in the agreement. Child support will be as ordered based on the minimum wage guidelines for 2 children with a step-down provision, as each child is no longer subject to a child support order, and the cash medical support will be $25 per child. The sole managing conservator, Ms. Branch, is ordered to arrange health and dental care for insurance for the children or to arrange coverage for the children under applicable government benefit programs that provide such coverage. And the respondents are each ordered to pay 50% of any uninsured medical or dental expenses of the children not covered by health insurance, dental insurance, or government benefit program. The department is discharged as temporary managing conservator of the children. And I will discharge Mr. Fleming and Ms. Roberts from their appointment 31 days after entry of final order by the court, reflecting the judgment announced by the court today. I'll ask Ms. Jordan if you could prepare and submit a proposed final order consistent with the agreement of the parties as announced today for entry.
Yes, Your Honor.
Well, thank y'all for working this out. I wish all of y'all the best of luck going forward. And again, I apologize for delaying getting started today. Thank you very much.
Thank you, Your Honor.
We're adjourned.